Hello, and welcome to IP Law 101. IP Law is the short acronym for Intellectual Property Law. And what that basically means is, I'm sure you guys, you're all creatives, and sometimes you're working on a concept, you're working on a speech, you're working on a presentation, and it's done, it's just all here. And then someone says, how far are you? No, I'm done, it's just here. So basically, intellectual property law describes the works that you create with your mind. It is your energy in action, it's your vision in action, it's your brilliance in action. And in a sense, it's the best way to express who you are and what you're all about. Intellectual property for many of us is our livelihood. And today I'm here to tell you about how the law protects your livelihood. As you know, I'm Helene Viljoen, I'm an attorney, and some background, I studied law, LLB, and I did my master's degree in social media, how South African law applies to the sphere of social media. I've served as the legal counsel for JSE listed company, and I'm also on the South African Press Council. I am a representative of the South African public. You may have seen my face or my name somewhere. I'm usually talking or writing about information law. Now that is your right of access to news, your right to freely express yourself, and your rights to privacy and dignity. That's what I am all about. And I believe that the law is there to empower you. It should be something that empowers you every single day. And many people don't feel that way. Many people think that the law is reserved for those with law degrees or those who fake being able to speak Latin. That's not what it's all about. Today, we're going to chat about you, your relationship with intellectual property, and the laws that protect the wonderful gems that you come up with. So obviously, the digitization of society has massively changed how we do everything. We meet differently. We're here online. Tonight, we chat differently. We connect with people differently. We fall in love differently. Some of you probably have swiped right or swiped left. And we listen to music on Spotify, gone are the CDs. Life has completely changed. And if this is anything to go by, the digitization of society will now also influence how you poop and how you think about how you poop. Because according to the Duke University, you can now incorporate smart elements into your toilet to analyze your stool and improve your health. Just when you thought life has changed enough, yes, that. So our tech world has changed how we express ourselves. And in the past, only newspapers and magazines could publish to the masses. Today, you can do it, I can do it, we can do it. And we get so excited about the fact that we're able to do it. We end up sharing all of our intellectual property, sharing all of our brilliance, and not making a cent of it. And that's where IP law comes in. How many of you, by a show of hand, have had your works exploited on social media? You can even tell me in the chat. So you log on to social media and there is your sketch, your quote, your work, your brilliance. Someone just shared it as if it belongs to them. That's actually not justifiable. And today we'll see how you can protect yourself. Has the law kept up? Is our law too old for these developments? And if not, how can I use it as an average Joe? So some not so average Joes have been using the right to intellectual property protection. Examples are the New York Times. You may have heard that AI has been stealing content from news publishers all over the world to inform what they tell you when you enter a search query. New York Times said that's not acceptable, and they took OpenAI and Microsoft to court. Back in South Africa, Media 24 drew the line after the umpteenth woman or man, but in this case it was two women, posted their articles word for word on WhatsApp. We have some South African writers who are very unhappy because people are sharing PDF copies of their books, robbing them of thousands of rand that they need to live from. And then on a larger scale, I am working on Project Goliath, which is a massive competition commission inquiry whereby South African publishers are confronting Facebook and Google, saying you can't keep using our news stories to keep people on your platforms. You guys know how engaging a news story is. If you see a murder story or you see a court story or something that really attracts your attention, you start talking about it on Facebook and you start searching for it on Google. And that's how Google and Facebook make their money, is by exploiting the intellectual property of South African media companies and the rest of us, bloggers, writers, speakers. So massive companies with budgets of millions are taking people to court based on IP violations, based on stealing the content that you came up with. So it's great. They've got legal budgets. Where does that leave you? Today, we're going to chat about how you can protect yourself. Firstly, we'll take a look at international IP law. How is intellectual property law regulated worldwide? Secondly, we'll look at the position in South Africa. And thirdly, I'm going to give you some tips. How can you protect the content you write, the beautiful art you painted, the book you wrote, or even your life-changing inspirational video or speech or presentation? So intellectual property, as I said, refers to creations of the mind. Think inventions, think books, art, design, symbols, names, and things we make money off of. Brand, a large part of your brand is intellectual property. And there are international regulations that sketch the bare minimum, the basic standards we all need to implement when respecting one another's IP. The fact that global regulation exists is a good thing, and South Africa is actually part of a number of international treaties that protect the ideas you come up with. We've got the Paris Convention that protects industrial property, the TRIPS Agreement sets international IP standards, and the Berne Convention is one I work with a lot. That is an international minimum standard for the protection of literary and artistic works, copyright, in other words. South Africa gives effect to these minimum rules with the following pieces of legislation. And I don't know if you know what the difference is between trademark and copyright. I'm going to illustrate that real quick. So the Trademark Act protects your brand, the word that you use to describe your goods or services. You know, if you see a cool brand name, they usually say Coca-Cola, TM. TM, trademark. That means Coca-Cola has the right to use the word Coca-Cola in connection with a beverage. So the Trademark Act protects your brand name in connection with your goods or services. The Copyright Act protects your art. It protects your text. It protects your photos, your videos. And the Patents and Design Acts protect your designs or your unique inventions. Now, today we're going to focus on trademarks and copyright, as they are more prevalent in the types of businesses that you're all in. Copyright, as we said, protects your artwork automatically. When does copyright start? Very interesting. You don't have to register copyright. If you take a pen and a piece of paper and you draw a smiley right now, that smiley is copyrighted. If I sing a song, la-la-la-la, I just sang you a copyrighted song. The moment you take a selfie, that selfie is copyrighted. The moment you bring a fantastic creative idea into creation, the moment you make it physical, that's the moment your copyright decides to protect you. And copyright lasts for your lifetime plus 50 years in South Africa. It's different in other countries, but that's the duration. So your material can benefit your kids, guys. If you pass away, they are covered for income for another 50 years. Trademarks, on the other hand, safeguard brand identity with logos and names. And a trademark is valid for 10 years, after which you can renew it. Moving on to the next slide. No, there we go. So let's chat a bit about trademarks. And the word COBRA is a brilliant way of distinguishing between trademarks and other forms of IP. So if you think Cobra and you think household cleaning products, you're going to think of the polish. If you think Cobra and you're building a house, you're going to think of the taps. If you think Cobra and you're a sportsman, you're going to think cricket balls, cricket bats. All three of those things are named Cobra. All three of them are protected as trademarks. Why is that? That is because we have an international trademark register. It's called the NIS register. And in terms of this register, you can trademark the word in relation to various different types of things. So polish is protected under class 3 because that's all household cleaning type stuff. The taps, the bathroom ware, is protected under class 20 because that covers household building products. And class 28 is all about sports products. So what if I want to write some software and I want to call it Cobra? Can I register that trademark? Yes, I can. Why? Because there's a distinct difference between floor polish, taps, cricket balls, and computer programs. I cannot, however, come up with a tile cleaner and call it Cobra, because that's too close to the floor polish. Just to give you some idea of how this works. You cannot trademark generic words. For example, I can't come up with a cheese and call it cheese. I can't come up with a newspaper and call it newspaper. I need to be a bit creative if I want a trademark that I can protect. Now, how can you register a trademark yourself? You can actually do it. It's very user-friendly. You log on to the CIPC website and you apply, you find the appropriate category. It's 590 Rand and you apply for a trademark registration. But why would I suggest having an attorney involved? The reason for that is if you come up with your Cobra computer program and you want it registered, the process entails that Cobra cricket balls, Cobra floor polish, and Cobra taps will be notified of your pending registration. And you will probably need a lawyer to explain then why your naming of a computer product branded as Cobra does not constitute a contravention of their rights. So it gets very technical. That's where a lawyer might have to get involved. And copyright, we're going to dive a bit deeper into that. So we know it exists the moment a creative work comes to life, doesn't have to be registered, except videos. If you have a video you'd like to copyright, get in touch with me or get in touch with the Department of Trade and Industry. You can do it yourself. And on their website, they have some nice guidelines, but again, it might be a good idea to have a lawyer on your side. Did you know that someone who steals your copyrighted content can get arrested? You may have known that we can sue them for money, but you can also have them bullfighted and sent to jail. That's always my favorite thing to threaten people with when I write them a cease and desist letter. So when is someone stealing your copyrighted work? When can we send them to jail and when will they have an excuse? What we have here is the scream. And this is very interesting. So the copyright on the scream actually still exists. And that is because the creator passed away in 1944. And in terms of Norwegian copyright law, the copyright lasts for 70 years after his death, which means it still applies. If you just copied the scream, that would be a blatant copyright violation. If you made prints of it and you sold it online, blatant copyright violation. But what if you are inspired by the scream and you just want to make a photo background like someone did here? There's an element of originality you cannot deny. And for that reason, we will not be able to successfully sue or to have them shipped off to jail based on this copyright contravention. So it is possible to be inspired by a work and use it without committing a legal wrong. Have you ever heard the term fair usage? Someone steals your stuff, they reproduce it and they say it's fair usage, I'm allowed to. Or my personal favorite, it's in the public domain. Then I just want to grab them and throttle them. I get so angry. So fair use only applies if somebody uses your intellectual property for academic purposes or for current events reporting. In other words, it ends up in the news. And when that happens, it's only justifiable if the person who reproduces it actually asked you for permission. They don't have to wait for your consent, but they must have asked. The work that they reproduced must not be that of a media professional, and they must limit it, the extent of usage for what is necessary for the purposes of news reporting. So if anyone comes to you with, I used your work because it's in the public domain or based on fair usage, you can counter that argument and say your understanding of the fair usage rule is incorrect and public availability is not the same as consent to reproduce. two very different things, and people misunderstand that. Okay, so now we're going to get to IP protection in practice. I'm running through this, but it's because there's a lot to share. What steps can you take proactively to protect your IP? Many lawyers are so happy when clients come to them and say, let's take someone to court because they're going to make money. Me, not so much. I want to keep you away from court, out of court. I want to protect your instant, your asset, your interests, your assets, your money, without having to pay 200,000 Rand to end up in a courtroom, because that's what high court litigation costs. So how do you get it right from the get-go? Step one, NDA. Non-disclosure agreements are your friend. It does not matter how much you like the people that you're negotiating with. If you're about to share your intellectual creations with them, have an NDA in place. Subsequent to that, general copyright management should be something you think of every single day. Ensure that the people you deal with are clear on your terms and conditions. Just want to switch to the next slide. There we go. Always have a contract. Someone was telling me the other day, we were talking about marriage, and they said, yeah, but it's not about the contract, it's about the love. I said, no, you're not in love, you're in contract. That's when it becomes real. So you should have the terms and conditions in writing, because that's where you tell them, this is how much my work is worth. This is how much you owe me. This is when you owe me. And this is what happens when you don't pay. It feels horrible to act like that, but that's your rule of thumb. That's how you protect your work. How do you benefit when sharing your content? We know that copyright doesn't usually require registration, except if you made some videos, then you go to the DTI website, or you speak to me or any other attorney. One easy way to protect your work is to put a copyright notice without fail. That's the C with a circle around it. The moment you do that, nobody can argue that their usage was justified based in public domain or fair usage, because that C expressly tells them that you forbid unauthorized copying. Always remember to add a copyright notice to any work that you make available. Get into the habit of monitoring the online use of your content. Photos are a good example. Do you know how to do a reverse image search? Give me a nod or a no. Have you done it before? Okay, so you jump onto Google. In the search bar, I'm actually going to share the instructions with you in the chat. I'll do that in a while. So you go onto Google. In the search bar, type reverse image search. Reverse image search. They will then give you instructions. So you upload your work. It works really well for photos. And Google then searches every single place where that photo has been reproduced online. That means you can track down the person who violated your copyrights, and you can give effect to your rights. Do that often. Use Google Alerts. Do you know how to do a Google Alert? If you don't, I shall send you the guidelines. It's a bit of a long story, but I'll send it to you in bullet points so you know how to do that. Check when someone's abusing your IP. Then you can do a Creative Commons license. So you go onto creativecommons.org and you assign licensing to your work to ensure that how you would like your work to be produced is out there. Nobody can say they didn't know. If we need to litigate, then we use your Creative Commons license to boost your case. Then there's very exciting technology that you can use. It's called digital watermarking, digital rights management, and right-click protection. So I'm going to start with right-click protection. You know, you right-click and then you say copy, and you right-click and then you say paste. Right-click protection disables that function. So if someone stumbles across your blog, they cannot just copy and paste, because it literally becomes impossible. If you go check out News 24's work, you can't copy and paste it. You can't even take a screenshot. And that is because they use these tools: digital watermarking, digital rights management, and right-click protection. This may cost you. The people who provide these services ask money, but two examples are Axonym. Check out their website. They actually have a free trial. And I'm a Tag, offer handy demos to show you how it works. By the way, I'm sharing my whole presentation with you because you're going to need these notes. I might be moving faster than you are writing. Okay, so now I want you to know, if you have an IP lawyer on call, that means you can pick up the phone 24 hours a day and say, hello, someone's stealing my stuff. Can we write them a cease and desist letter? Or I want to protect this piece of intellectual property. How do I do that? How do I avoid ending up in court, having to pay litigation fees just for the right to earn an income? That's why I always advise that you have an IP lawyer on retainer, an IP lawyer on call. And I'm going to just stop me if I'm not allowed to do this. I actually have a very nice special for you guys. A monthly retainer, it's 2,500 Rand a month in exchange for 5 hours of IP law services, and the hours you don't use accrue. Trust me, it helps to say, don't talk to me about this, talk to my lawyer, or stop stealing my stuff, but I'm not going to warn you, she's going to. And I hope that I haven't run out of time because I've really been a steam train. It's time for questions. Tell me what you want to know.